All right, we're going to go ahead and call to order the City of Wilmington's Board of Adjustment meeting. Today is Thursday, July 17th, 2025, and it is 1:01. Before we get started, I just want to read the Board of Adjustment introduction. Hearings before the Board of Adjustments are quasi-judicial in nature. Decisions of the boards are based on the record of these proceedings. To grant a variance requires concurrent vote of 4/5 of the members of the board. To reverse or modify the determination of an administrative official requires a simple majority. Evidence submitted to the board for review becomes part of the record. Appeals of the board's decision to Superior Court are based on the record. Appeals must be filed within 30 days of the date of the filing of the board's order in the Planning Division. A hearing before the board is conducted in accordance with the rules of procedure. Those who want to testify in a case are sworn as witnesses. The chairperson recognizes those who want to testify or their attorneys for presentation of evidence during the hearing. To ensure that all testimony is properly recorded, please come forward to address the board, state your name, address, and speak clearly. Next thing we'll do is swear in anyone that's going to speak or present information today.
I'll ask that staff, applicants, and members of the public who wish to speak today, if you'll stand and raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
All right, thank you. Our next item is going to be the approval of the minutes from the June 12th, 2025 meeting. If there isn't any changes, I'd take a motion for approval.
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Anyone opposed? Meeting minutes are approved. We have two items to clear up on our agenda. Want to go ahead. We have item 2, the applicant is withdrawn, so we don't really have to take any other action on that, correct? Is it applicant request withdrawal from item number 2 for 117 South 8th? Are we good on that one as a withdrawal? Okay. And then we also have a continuance, item number 4 for 1225 Great Oak Drive for the variance to request a bulkhead extension in the R20. Is that date specific?
That'll be the August 18th meeting, the next regular meeting.
August 14th.
August 14th.
Oh, I'm sorry, yes, August 14th.
Okay.
Sorry.
All right. So
Make a motion to continue item 4, 1225 Great Oaks Drive to the August 14 meeting.
all right. Is there a second, please?
Second.
All right. All those in favor say aye.
Aye.
Anyone opposed? That's continued. All right. We'll start with item number 1, 6228 North Bradley Overlook. Appeal of a zoning officer's determination that 2 trees located within the conservation resource overlay do not meet criteria for removal as set forth in the City Code Section 18-317.
Mr. Chairman, I need to recuse myself from item 1.
All right. And
Graham will be coming up to take my place.
right.
No, I'm sorry, Greg's already will be coming up. You're already here. Keep that seat warm.
all right, Catherine.
Thank you, Chairman Huffis, members of the board. The subject property contains a single-family dwelling located in the R15 residential district, and the property is surrounded by residential properties on all sides and abuts Bradley Creek to the south. The owner has proposed to remove 3 pine trees on the subject property, 2 of which are located in a conservation resource setback area, in which tree removal is limited to those meeting the criteria for removal set forth in City Code Section 18-317. Tree number 1 is a pine tree in the front yard, and it's outside the conservation resource area and exempt from permitting requirements. Trees 2 and 3 are subject to LDC sections 18-286 and 18-287, which states that conservation resource setback areas shall not be cleared of vegetation, and plant material within the applicable buffer has to be retained. On February 20th, 2025, city staff inspected the subject property and determined that tree number 2 met the criteria for removal due to lightning damage on the trunk, which you may be able to see in the slide in front of you. The city arborist determined that tree number 3, a loblolly pine, did not show any signs of poor health and did not meet the criteria for removal. And here are some photos of that tree. On April 28th, 2025, the applicant submitted an appeal of staff's determination, and this matter was set for hearing by the Board of Adjustment on June 12th. However, the posted public hearing notice was removed, necessitating a continuance to the July 17th meeting to ensure proper notice. I'm happy to answer any questions that you may have of city staff. Our arborist and the officer who inspected the subject property is also present if you have any questions for them, and the applicant is also present.
Okay, all right. Does anyone have questions for Catherine? All right, thank you.
And I'll just put the criteria up for you.
Would the applicant like to speak?
Good afternoon. My name is David Flory, and this is my wife Millie with me today. We live at 6228 North Bradley Overlook. We're here to request permission to cut down a large pine tree that we feel would endanger the health and safety of our home. We've lived here for 27 years. We bought and built in this subdivision because of the trees. Parsley Woods has very strict bylaws and covenants on cutting trees beyond the 10-foot footprint of our house. During Hurricane Isaias in August of 2020, a Category 1 hurricane came in landfall near Ocean Isle Beach. The wind off the marsh was very strong. A large pine tree on our property broke about the 15 to 20 foot level up and landed on my neighbor's house about 50 feet away. With climate change and the intense hurricanes, we fear the winds coming off Bradley Creek would blow and break this pine tree into our home. Fran, 1996. I'm not certain how many of you lived here, but it conveyed a lot of damage. We lived off Eastwood Road, had a yard full of pine trees. Hurricane Fran broke almost every single one of them. I have pictures if you're interested in seeing them. I had 2 on my house. The air smelled of pine as it does after hurricanes. Almost every pine tree that broke snapped at the 20-foot to 35-foot height. Fast forward, 1994, we bought a lot in Parsley Woods. The lot was fully wooded, and we liked that. We built in 1997. We could only cut within the 10 foot of the footprint of my house. The HOA had a very strict rule on cutting trees, and it has been enforced. 2024, bylaws and covenants were adjusted in our subdivision. With a 40-year-old subdivision, there was lots of concern over the growth of pine trees and how to manage them. New criteria, and this tree, tree number 3, was approved to be cut by our subdivision as it was larger than 26 inches at the base. The size of the tree. For our HOA, we were asked to measure 1 foot above the tree base. My tree is a 31-inch in diameter at this point. For the city of Wilmington, on table 18-316.1, for a significant or specimen tree, the minimum diameter at breast height is 24 inches. I measured last night. I do have a picture of myself measuring the tree. At breast height, my measurement is 23.88 inches. So this height, at this point, the tree is not necessarily a specimen or a significant tree. CAMA. I made a phone call into CAMA, the Coastal Management Local Division. I spoke with Kelsey Beachman on January 29th, 25, and identified the pine tree I wanted to cut. After her research into my property and location, she told me that I could cut it to grade, which meant I'm not allowed to remove the root ball or take anything below grade. When we bought our lot, there were no tree regulations for our lot from the city. There were no ordinances, there were ordinances related to trees possibly in 2008, further defined with the Land Development Code in 2021. Since I owned the land prior to these ordinances, the question that all my friends have been asking me, am I not grandfathered? Am I not exempt from those ordinances? I have 2 pine trees that I fear would cause damage to my home and my family should a large windstorm come through. We have been approved for tree number, identified as tree number 2, was damaged by lightning about 35 feet up. The pine that I'm requesting is the largest pine tree within 35 feet of my house. If the wind comes off Bradley Creek Marsh, the top of this pine would land in the middle of my home. This is a dangerous situation that I have the ability today to fix before it happens. I'm therefore making a request that we approve removing, yes, it is a healthy tree, but my request is to be able to remove the tree. That's all I have.
All right.
Millie, did you have anything you wanted to add? Questions?
Does anyone have any questions for Mr. Flory? All right, thank you, sir. All right. We're going to go ahead and move forward to the evidentiary hearing. I'll go ahead and open evidentiary hearing. Is there anyone that would like to speak in regards to this matter to add additional information relevant to this? All right. I was wondering if we should have our arborist, our tree, the city person to talk about his, yeah, we might as well do it while we're in the evidentiary side of things. Thank you. Yeah.
Questions or just?
Yeah, just for the record, if you could state your name and.
Aaron Reese, City Arborist.
All right. Yeah, I figured while we were in this, if anyone had questions related to this tree. Anybody?
I have a question. I don't know if it's for you or if it's for legal counsel.
Sir, if you could make sure that the microphone is turned on that's in front of you, and Mr. Reese, if you could put the mics up just a little bit for you. Thank you.
There we go. So my question, I'm not sure if it's for you or for legal counsel or who, but the issue of grandfathering that the applicant mentioned, does that apply in this case or not, if they purchase the property prior to the ordinance?
No, this wouldn't be subject to being considered a legal nonconformity or be vested under prior ordinances.
Okay.
Whenever properties are annexed into the city limits and when an ordinance goes into effect, it applies to all properties that are within that area and to which the ordinance would be applicable.
Okay, thank you.
Anyone else have questions?
I had a question. Tree number 2 was struck by lightning. Would that meet the criteria for item number 2 on this list?
Yes, because of the injury from the lightning damage.
Yes?
Yeah, the criteria for permit issuance, it would fall under number 2, yes.
It would meet that?
Yes,
Okay.
because of damage sustained from the lightning strike.
Yeah, great.
And you determined that tree number 3 didn't meet standards
Yes.
in your review.
Yes,
And
correct.
just to elaborate, just for the purpose of the members here.
Sure. So when we review trees, I am able to do a ground level visual inspection. So that's all I have at my disposal on private property for non-city trees, obviously. So there was no indication that the condition of the tree met any of these 6 criteria. Therefore, the recommendation was denial of the permit.
Okay. All right. Any further questions? All right. Thank you. All right. I'll just see again if anyone has anything else while we're in the evidentiary side. All right. Anyone have questions for the city while we're during this process? All right. We'll go ahead and close the evidentiary portion and we'll move forward. Does the city have any additional information for
No,
or
just
rebuttal?
happy to answer any questions that you may have. It's just the city's position that the tree did not meet the criteria for removal, and I believe the applicant stipulated to that as well.
Okay. And anybody have questions for Catherine? All right. Mr. Flory, do you have any further things you'd like to? What I have to do is I'll open up the evidentiary. That's during the evidentiary is when we do that. So we'll go ahead. I'll reopen the evidentiary hearing. And you can come forward to, if you have information to present. And
Yes, my name is Bob Weiler. I am a neighbor of theirs.
I'm sorry,
Yeah.
I'd like to point out that you'll need to be sworn
oh yeah,
by our
okay.
clerk.
We'll just have you be sworn in since you're.
You'll just raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you.
And just state your name and address, just for the record.
Bob Weiler, and I live in Parsley Woods, 6613 Sedgewood Road, which is just around the corner from the Florries. So a couple of things. One, I would just say that I've had a tree in Florence fall on my house, a big pine tree, probably 22 inches in diameter at the base, and it fell on my house, damaged my house, came down and broke a couple of windows and damaged the roof and did all of those kinds of things, which happen quite often. So that's one thing. But the question I have about the legal matter, if the city denies the removal of a tree and the tree subsequently falls for this very reason the applicant has asked for its removal, is there a legal condition that the homeowner may have against the city or the Parsley Woods Homeowners Association that may have denied such a tree? And then the damage occurs once that's been denied. Is that perhaps a legal question?
And yes, sir, I would have to advise you to seek independent legal counsel to answer any legal questions. I cannot answer that question or provide that legal advice to you, and everyone else in the room is prohibited from providing legal advice at all.
Okay. We'll do that, but that's a question that we have within the Homeowners Association. If a condition occurs once it's been denied by the city or by the homeowners or anybody, and that condition then occurs, who's liable or who potentially suffers the challenge from the homeowner about that condition, Phil?
Okay.
Okay.
Yeah, be noted. Thank you, sir.
Thank you.
All right. While we're still in the evidentiary, I can, yes, sir.
I did have one more thing to add. Per our HOA association, the possibility of mitigation. So on certain trees, you can replace a tree. And so in asking our HOA for permission to cut down the tree, we indicated that we were prepared to replace with a tree. And I've got a couple spots, we're going to put some Leland cypress up in a spot. So should we cut this tree down, when we cut this tree down, we'll replace it, not on the same location, but on the side of our house where it's kind of protected, but a Leland cypress tree of significant size, so.
Okay. All right. Thank you.
Any other?
Anybody have questions of the applicant? All right. I'm going to, if there isn't anyone else, I'll ask one more time. Does anyone else have anything else during the evidentiary? All right. I'll go ahead and close that. We'll come back. Does the city have any rebuttal or additional
Nothing.
information? Thank you.
Nothing further from the city.
Bethetta?
Thank you.
All right. Does, Mr. Floyd, do you have any additional information for this matter? Okay, thank you. All right. Moving forward, we'll talk about your wishes as a group. Any discussion?
The only question that I would have at this point is regarding the second finding of fact regarding the conditions of the property being peculiar, such as location, and whether this tree being removed is due to it being in its positioning in the lot, in which if the wind was to take down this tree during a hurricane and that was to damage the property, are there other trees that are being ignored that are not being removed? Does that make sense? Mm-hmm. Is it strictly this tree in particular that they would like to move because of the height and the trajectory in which it would fall and damage the property, and there are other trees around it?
This is the only tree that's under consideration for today, but there are other trees within the neighborhood.
Well, okay, I understand.
Other thoughts?
It's pretty obvious to me that tree number 2, and that's not the one they're appealing, correct?
That's correct. We approved the removal of tree number 2, and tree number 1 did not require approval.
So I'm having trouble finding a reason to allow tree number 3 to be removed. I just don't see it, based on the findings of fact and the criteria for permit issuance.
Right. Is anyone else?
If I may just remind the board, this is an appeal of staff's determination rather than a variance. So the 4 criteria for granting a variance wouldn't be applicable to this case.
Can you say that again, Catherine?
This is an appeal of staff's determination that the tree does not meet the criteria for removal in front of you. It's not a request for a variance, so you would not need to apply those 4 conditions for a variance.
Okay, that's very helpful. Thank you.
Yeah, just have to see if you want to uphold the staff's
Okay.
decision. All right. Anybody have anything, motions related to this? I guess.
I make a motion to uphold staff decision.
Right, there's been a motion to uphold the position. Is there a second?
I'll second that.
All right. All those in favor say aye. Aye. Anyone opposed? The staff's decision has been upheld. We'll move on to new business. Item number, we'll bring Patrick back. Sorry, forgot about you over there, sorry. Yeah. All right, welcome back. We'll move on to new business, item number 3. It's 5123 Market Street, a variance to City Code 18-391 to exceed the allowable area for menu board signs. And Tucker, your first presentation in front of us, right?
Yes, sir. Good afternoon, Mr. Chairman, members of the board. Today's variance request for 5123 Market Street is a request for menu board sign, additional signage. The Chick-fil-A is located on Market, the intersection of Market and New Center, as you can see here. The subject property is in the RB Regional Business Zoning District. According to New Hanover County tax records, the subject property is approximately 1.12 acres, and the former Chick-fil-A there has been demolished on or about June 19th, 2025. The applicant is proposing to construct a 4,674 square foot restaurant with a 2-lane drive-through and associated equipment, which would be located between the proposed commercial structure and the Market Street right-of-way. Here is their site plan showing the driveway on the south towards Market Street right-of-way. Pursuant to City Code Section 18205A, a drive-through facility shall not be located between a building and the right-of-way, nor shall it be on the same side of the building as the primary entrance. However, the previous building did not meet this standard, and the current proposal to place the drive-through is generally in the same location. Therefore, an additional variance to this standard is not required. Pursuant to City Code 18391B, drive-through facilities shall be allowed an additional 30 square feet of signage within 2 feet of the drive aisle. Such signage shall be oriented away from any adjacent right-of-ways or shall be shielded by vegetation or other solid visual screens such as the additional signage so that it is not readily visible from the adjacent right-of-way. The applicant states that the expanded 2-lane drive-through will require menu board signage for each lane. The proposed signage is 27.45 square feet in area on each sign, which is a total of 34.9 square feet. To note, each sign independently would meet standards laid out by the city. Just the fact they have 2, 1 for each lane, brings it over the maximum square footage allowed. And on June 6, 2025, planning staff accepted an application for a variance of 24.9 square feet to the maximum 30 square foot allowed for drive-through menu boards, and the matter is set for hearing today before the Board of Adjustment. I'd like to submit this into the record and open it up to any questions you may have.
All right. Does anyone have questions of Tucker? All right, we'll probably have some later on, but thank you. All right. Next, would the applicant or the agent for the applicant like to present?
Good afternoon. My name is Tom Johnson. I'm an attorney with the law firm of Williams Mullen at 301 Fayetteville Street, Suite 1700 in Raleigh, here on behalf of the applicant Chick-fil-A. It wasn't too long ago that I was before this board with the very same issue. for the new Chick-fil-A at Shipyard and Carolina Beach Road, where the board approved, which we appreciate, the additional menu board because of the dual drive-through lanes at that location. That's a new store. This is an existing store that's in the process of being redeveloped. Two different divisions handle the different parts of it, the new stores versus the redeveloped stores. So this got overlooked during the approval process, and it wasn't until the staff comment that we couldn't exceed could have the menu boards for both the drive-through lanes, which is the same design that we talked about at Carolina Beach Road. Dual drive-through lanes to improve efficiency of vehicles moving through the site and to prevent backups off the site and potentially backups into the adjoining road. And this is at the intersection of New Center Drive and Market Street. So that's the reasoning behind needing the additional drive-through lane. And additional factor is obviously the customers. There are more customers using drive-through than in the store now versus when the store was initially built. So that's why the change in process and the change in need here. The 30 square feet, per drive-through lane isn't sufficient to be able to handle the dual drive-through lanes, nor was it meant to. Obviously, we've talked to staff about in the future maybe amending the ordinance, but at this point, this site's actively under redevelopment, and we asked the board for a variance based on the criteria. And I think Tucker already asked that the application and associated documents be admitted into evidence, and I will reiterate that we'd like that as well. I have Matt Zipanzik representing Chick-fil-A, and Kevin Gomez, who's with Interplan, who is the engineer on site and did the plans. They're here and available to speak to any questions you may have. But basically, that's why we're here, because of the dual drive-through lanes and Chick-fil-A's experience on how those function more efficiently and safely than having one drive-through lane. And so I'm happy to answer any questions you as a board may have, but this is, like I say, no different than the one that was previously approved at Shipyard and Carolina Beach Road.
Anybody have questions for Mr. Mullins? All right, thank you, sir.
Thank you.
All right, we'll go ahead and move into the evidentiary hearing. I'll go open that up for anyone who'd like to speak for anything relevant to add to the record. All right, while we're in this, does anyone have questions of the staff or the applicant during the evidentiary that you'd like to make? All right, I'll go ahead and close the evidentiary hearing, and we'll move forward in discussing how to move forward on the request.
In reading the four findings of fact, I think item 4 kind of carries a lot of weight with me in that the public safety is secured. I think this allows for better traffic flow and more safety for the patrons of the establishment and the traffic driving around the establishment on New Center Market. And there's also that side street on the other side that comes out of the parking lot. So it's surrounded by rights of way and roads.
Anyone else have thoughts? I just have a question for us, city. Have we thought about the rewriting of this allowance for signage with the cause of the dual? Because we're gonna probably see it in a lot more of these.
We've spoken to the applicant about the potential for an applicant-initiated text amendment because we have seen Chick-fil-A come forward with similar requests in the past. And this is only relative to the signage, not the dual drive-through lane. That's already allowed under current code. But yes, we have had conversations, but we don't have any plans currently to make that amendment at a staff level.
Yeah, it seems like we have the dual drive that automatically the signage would come with it. And I'm just curious if we're going to see more of these from other people that are renovating. I'm just putting it out there. It's not we don't get to do it, but maybe our city council, they might want to consider that.
And I just want to say, I mean, we may consider, helping initiate that. I talked to staff about it. At this point, I don't have a specific request from Chick-fil-A to pursue the text amendment, but it does make sense given the situation that dual drive-throughs, as was mentioned by Mr. Moore, secures the health and safety, which is what we were after in this location. And if you have dual drive-throughs, obviously you need menu boards at each drive-through lane.
Yeah, okay.
Thank you.
Thank you, sir. All right. Anybody have anything else? Questions or motion?
I would motion to approve the variance to exceed the allowable area for menu board signs.
All right, there's been a motion for approval. Is there a second?
Second.
All right, we have a second. All those in favor, say aye. Aye. Anyone opposed? That variance is granted. Okay, that ends the items we have on our agenda. Does the city have anything?
Well, I would like to welcome Tucker Cherry. You'll be seeing more from him at future meetings. He is a new Planner 1 with the city's zoning division, and we're very happy to have him.
Yeah, welcome. Yeah, thank you. I was to remind everyone that our next meeting will be August 14th, and it will be in this building, which will be probably our last meeting in this building. All right, if there isn't anything else, oh no. If that being the case, we can adjourn. All right, thank you.